The next bills to discuss, the first one is LB292 that deals with central registry changes. Again, this indirectly impacts our office, but what this bill and now statutes state that if a case is dismissed by a court or a juvenile petition has been redesignated to indicate that it is a no-fault petition due to no fault of the parent, the case shall be immediately expunged from the central registry. What that means for each of us within the foster care review office and our review process is that these individuals will not be placed on that central registry. It also goes on to state that if the petition filed is a no-fault petition, the case shall not be entered into a central registry. So as we do our case file reviews, it is very important for both our review specialists and for our local boards to make a determination whether this was a fault petition against the parent or a no-fault petition against the parent. Some other changes to the central registry deal with the placing of minors, some child younger than 12 years of age on the central registry. The statute now specifically states that a minor younger than 12 years of age shall not be placed on a central registry. If the child is older than 12 years of age up to 19 years of age, the case shall not be classified as court pending. In other words, there is a requirement now that if you're going to place a child age 12 to 19 on the central registry, there's a mandatory expungement hearing that has to occur within 90 days of notification to the guardian, custodian, or parent of that 12 to 19-year-old that they are going to be placed on the central registry. What they found was that we had youth as young as 4 and 5 years of age in the central registry, and the whole goal of LB482 is to clean up the statutory requirements. But again, the main impact for our office deals with those no-fault petitions. The next bill to discuss is LB294, and this is known as the human trafficking law. This bill indirectly does affect our office. The law is very detailed and defined as to what is human trafficking from a criminal standpoint and from a juvenile standpoint. But the one thing this bill does that impact us is that it requires Health and Human Services to report to the Foster Care Review Office information regarding any child that was a person immune from criminal prosecution under human trafficking laws or was considered a human trafficking victim as defined by the statutes. The senators are really looking at us to provide any data or any information in the next upcoming years as to how many victims, juvenile victims, are involved in human trafficking. Next bill to discuss is LB482. This was a juvenile justice bill. This bill contains two important sections that impact our agency. The first is with regards to status offense youth. Remember, a status offense youth is any youth that has not committed a criminal act, but due to their age, they are considered either a runaway status or not going to school, they are truant or ungovernable, they need the assistance of the court, but it's not a criminal act. What this statute now says is that a status offense youth shall not be placed in a juvenile detention facility or in a staff secure facility unless that staff secure facility is only staff secure because of staff supervision, not because of a locked egress door. It also states that status offense youth shall not be placed in out-of-home care as a dispositional order unless two things have been met. First, that all available community-based resources have been exhausted, and second, that maintaining the juvenile in their home represents a significant risk of harm to the juvenile or the community. It also states that fingerprints for status offense youth shall not be taken. Lastly, what it requires is that prior to filing a petition for a status offense, a county attorney shall make reasonable efforts to refer the juvenile and their family to community-based resources. If the county attorney does not do that, this is a defense to the adjudication, which means that the matter can be dismissed. These changes with regards to status offense youth are important to the Foster Care Review Office because, as I'll explain, under LB265, we will be now reviewing status offense youth that are under probation jurisdiction. So we need to be paying special attention to status offense youth. The last thing that 482 did was with regards to restraints. What this statute now says is that restraints shall not be used during a juvenile court proceeding on any delinquent or status offense youth, must be removed prior to a hearing, unless the court makes a written finding of probable cause after providing an opportunity for the defense attorney and for the youth to be heard on the use of restraints. It can only be used if it's to prevent physical harm to the youth or another person, or because the juvenile has a history of disruptive courtroom behavior, or there is substantial flight risk. Basically what this statute says is that restraints shall not be used in court unless there's no other alternative, and it has to be a judge-based decision. As we review these probation and delinquent status cases, we will be looking into the matter as to whether or not youth have been restrained appropriately.